There are questions about the autochthony of the 1999 Constitution. The Nigerian people that make up that phrase, we the people, were not involved in the process of making the 1999 Constitution. So in the sense in which, David has made his point, there's a fundamental fraud there. There's a fundamental fraud there which we ought to address going forward. But the basic point I want to make is this. If you have the drafters of a constitution and the operators of a constitution who do not understand that you can interpret the constitution through the texts that make up the constitution without going outside of the constitution, that you can understand the constitution on the basis of the triad that Montesquieu created in his theoretical philosophy, that there must be some level of divisions between the branches of government and also between the structures of government. What do I refer to as the divisions of government? I refer here to as the branches: executive, legislative, and the judicial branches of government. And of course, the structures of government, the federal and the state. For some of us who are watchers of the Nigerian political process, you will recall that few weeks ago, the present government told Nigerians that in an attempt to ameliorate, the economic hardship that we all confront as citizens of our country, there are plans, underway for federal government to allocate lands, to farmers across our country. Any operator of our constitution will understand that the issue of land ownership does not devolve around the powers of the federal government. So we have operators of our constitution today who do not understand the theoretical, underpinning of our constitution. And it's a fundamental problem. Thank you.
Thank you, the great Oracle, for that insight. So I think we'll go ahead and start the QA. Barrister Kelechi was going to speak, but I think he probably dropped because of network. Once he comes back, we'll come back on to give us his insight. But at this point, I will let Liberty Champion to go ahead and request, whoever wants to speak, just kind of bring up people who have questions to answer, and then we can go from there. Thank you so much.
Thank you, the host. Peter B, Grassroots Mobilization. I don't know if you have anything to chime in before I continue to the next step. My co-host.
No, absolutely. Go ahead.
Thank you.
Thank you so much.
Thank you very much. I'm just looking on the thread before I call in those who want to ask a question. Elder God is saying to us, hosts, that we should post all the sections in a continuous thread for him, as he's having to search for the chapters that you've published so far. So please take note to post that in a continuous thread.
Sorry. You can go on my Twitter profile and go to the media part of it, and you will be able to see all the pages that we've read so far.
Okay, so Elder God, I hope you can hear that. If you go on IBTech Twitter profile, you see all the sections. Also, there's a question here on the thread, and from Unduka Joseph. Hopefully, one of our guest speakers will be able to speak to this. Why is there no institutions apart from the police who will be waiting for instructions from above, empowered to carry out immediate prosecution when court judgments are made, and such institutions be held responsible if they delay? I'm sure our panelists understand the question. I'll take it again. Why is there no institutions apart from the police who will be waiting for instructions from above? I think he probably means from the authorities, empowered to carry out immediate prosecutions when court judgments are made, and such institutions be held responsible if they delay. from Unduka Joseph. Please, our panelists, anyone willing to tackle this question for him? Thank you.
I wanted to come in first. Can you hear me?
Yes, Baron, we can hear you.
David and the Great Oracle has actually evoked a very important discussion, a very important point, which I think a lot of people will understand. So, the dichotomy between the 1960s.
Baron, we've lost you. I'm guessing I hear the call come through. Baron, are you back? Okay, I think, Ugo, you probably want to try and answer the question. If Baron comes back, then you yield him the mic. Ugo, you have the mic. Thank you.
Thank you very much, Lifa. Let me start by just expressing my appreciation to you and to the co-host as well for all that you're doing for the movement in terms of enlightening the public about. This is such a brilliant initiative. We need to see more fora like this where people come together and talk about the constitutional framework, the powers of government, our rights as citizens. I said in the previous space that if there's been a silver lining to this electoral process and a lot of the struggles that we have engaged in, it's that a lot of people have been enlightened about just the possibilities of building a strong democracy. Also want to appreciate the panelists. Great Oracle, I salute you, sir. Thank you so much for all that you do, just inspiring us, enlightening us, educating the younger generations about, because we as young people, just as an aside, I want to say that we like to think that what we're doing is revolutionary, but there's a rich tradition of revolutionary struggle in Nigeria. The struggle for democracy has been a long one. It has been protracted, and we have so much to learn from our past experience as a people. So I just want to thank you very much for all that you do in this regard. To speak to the general theme of this space, I agree. I think that one of the problems that we have is the 1999 Constitution is the perception is that it's illegitimate because of the way in which it was promulgated. And that has to do with the peculiar historical circumstances, leading up to the transition in 1999, the sudden death of Sani Abacha. Before that, we saw the annulment of the 1993 election. The population was traumatized. The 1993 election was a culmination of a very protracted process as well. Starting in 1986, Babangida had formulated this very protracted process leading up to a democratic transition. People thought it was going to culminate in the restoration of democratic government in 1993, but unfortunately the military annulled that. We saw how Chief Moshood Abiola died in incarceration. He was unable to reclaim his mandate. And then all of a sudden, it seems like we stumbled into the Fourth Republic. Interestingly, it seems that at the time when the 1999 elections were held, the Constitution had not even been enacted. So people didn't even know. Very, very ridiculous. They didn't even know the provisions of the constitutional framework that would govern the Fourth Republic. And people were going to the polls, casting votes. People were campaigning. There was an electoral process. And yet Nigerians didn't really know the document, the nature of the document that would govern the political process in the Fourth Republic. So it's a very big issue. And you can see, because, as some of the other panelists have highlighted, because of that perception of illegitimacy, people have become detached from the political process. The Constitution, they haven't taken ownership of it because it's not really, the sense is that it's not our document. Many speakers have pointed out that the preamble opens with a lie. It says "we the people," but was there at any point in which Nigerians came out to say, "This is our document, we understand it, and we adopt it in a referendum"? This is the process that has been adopted in many other democratic countries. So it's a very big problem. We don't know. There are many of the problems you see in Nigeria today. I think Great Oracle was talking about how many of our political representatives have an impoverished understanding of the principles of government. They don't understand the rule of law. They don't understand separation of powers. I mean, a few years ago, there was a popular influencer that came out to contest for a legislative office, and this person didn't even understand some of the basic roles of lawmakers. Didn't have any idea what the separation of powers was. People don't know what the judiciary should do. People don't know the role of the executive. For instance, we're talking about a possible war with Niger Republic. This is something that has to do with the war-making powers of the president under the constitutional framework. It was when people there was a public outcry on Twitter saying that this man, you can't go to war unilaterally. The power to wage war is fractured between the legislature and the executive. If the executive is waging war, they must be waging war on the basis of permission that has been granted by the Legislative Assembly. That was when we then saw the executive rushing to submit a request, if they have even submitted a request to the National Assembly. So we need to deepen knowledge of our constitutional framework in this country. And so this is why this initiative is such a brilliant one. But beyond the question about the illegitimacy of the 1999 Constitution, I think that we also have to talk about our political culture. And this is where the operators of the text of the Constitution come in. You can have a fantastic Constitution, you can have brilliant constitutional provisions, but if the lawmakers, if the judges, if the members of the executive branch have not internalized the right sort of values, if they don't understand what it means to hold public office as a public trust, they will subvert, they will frustrate, they will distort even the most beautiful constitution. So all of these things go hand in hand. We want to see a constitution that is enacted through a democratic process, but we also have to ensure that those who are entrusted with public authority, public office, also internalize the right sort of values. I mean, if the Constitution says, as the National Assembly, for instance, you have to approve certain category of executive officials, they come before you, you don't ask them any questions, you don't scrutinize their record, you ask them to take a bow and to go. I mean, that really is not something that has to do with the text of the Constitution per se. It's the fundamental lack of understanding demonstrated by those in the National Assembly. So we have to deepen our understanding of those values and the right attitude and the right framework. These are processes that should work hand in hand if we really want to consolidate our democracy going forward. So at this stage, I'm just going to stop for now, but thank you again for putting together this space.
Thank you, Ugo. Baron, I'll let you come back in. After you've spoken, Baron, if you can please try and answer the question by Unduka Joseph. I've tweeted it on the JT. Thank you, Baron. If you need me to recap it, I will.
What I was trying to point out is the issue with the 1999 Constitution and the 1963 Constitution. So the reason why I wanted to point out that, which for me, I think one of the problems that's happening in Nigeria.
Baron, we've lost you again. I think at this rate, I'm going to give it to Kelechi. Pastor Kelechi, please, if you can try and answer our question and add your submission. Thank you. Maybe when Baron is lucky to come back. You have the mic.
Good evening, good afternoon, good morning, everybody. Thank you so much, host and co-host. Great people that are here. My learned senior colleague, Great Oracle. It's a pleasure sharing a space with you and most of my distinguished colleagues that are here. I thank all of you for finding out time for us to put heads together and then chat a new discussion as it relates to the Nigerian working document. Now, I will start with the question being thrown by Ndoka Joseph. He's asked why is there no institution apart from the police which will be waiting for instruction from above, empowered to carry out immediate prosecution when court judgments are made and such institutions be held responsible if there are delays. Now, by reasons of our laws, even private persons are allowed to even make arrests if they are so directed, and there are citizen arrests. There are it does not just lie on the citizen, on the police alone to or make this enforcement. If let's say a court of law directs, the court has the right to direct any security agencies in to help it in compliance of in the execution of its orders and judgment. So it does not really lie on the police alone, but traditionally we've made it in a way that it's only police that are being invited for execution and implementation of such judgments and orders. But however, court can direct any of the security agencies to aid it. Its function is not just to carry out that prosecution or implementation of that enforcement, but to aid the court. Usually, in terms of enforcement, there are usually key parties which are the persons who the court itself, which are most times represented by the court staffs and the rest, and the security agencies in carrying out these enforcement. So, in either which way, it does not lie legitimate only on the police. Any of those security agencies can or even private individuals as it may be can be ordered or directed by the court or any of such institutions to help it in its implementation. Now, going further to away from that question, I have listened keenly to the contribution, well-meaning contributions from my colleagues and friends that are here. It's beautiful and it's amazing, and I'm happy that they are giving these opinions. And just like the great oracle said, we have a problem with the constitution, and we also have a problem with the implementation of the constitution itself. Now, the constitution in its entirety is not the problem. At least we have some sections and some provisions of the constitution which are intended with what the reality is. We have some that are, it's not entirely the entire provisions that are condemnable. There are the ones that are okay to a large extent, and we have been making use of that. But however, we have had largely problem with the implementation and interpretation of the constitution. This is largely orchestrated by the fact of the recruitment we've had over the years. Now, like he mentioned, Dr. Chijodin Carlo has specifically on several occasions talked about how judges are being recruited. Now, if we look at the ways and manners that judges are recruited, you realize that we have no proper input into the justice system. That is, we have no proper input to the bench. As of today, we have over 150,000 lawyers, and by average, we have like basically at least 50,000 that are into active practice. Now, we have in the recent years seen the recruitment of our judicial officers being given to even persons who only the qualification they have is because the constitution tax a certain years as the minimum year you must be in, like the high court judges and the rest, who takes it at 10 years. One wants your 10 years. So the moment a person turns 10, even if he's not in practice, even if he has never smelled courtroom, even if he has never written any brief in law, he is assumed qualified to man the bench, and he's given. I have seen one, even from Ebonyi State where I come from. In the past 6 months, there has been appointments that were made. To tell you the worst, the persons that I saw on those lists were not persons who will even be qualified to practice even in the magistrate court. Most of them have never in their entire lifetime handled not even one brief. One. Most of them have been, okay, they were into their businesses, and maybe they are on their side also. They attach themselves to a firm, and when firms are writing brief, they include their names. as persons who are in the law firm, and that's how they get their names into law reports and into court documents when judgments are being written. Such persons will now apply to be judges who will sit and adjudicate on matters that come, matters that are life-threatening, national issues, matters that are concerns the active implementation of the law. Haba, we could do better than that, and that is on one part. Now, some provisions of the Constitution has made it very unapplicable. Now we have some provisions like the entirety of the chapter 2, as beautiful as they look, as glamorous as they look on the face of it, they are a beautiful nonsense. You know, they provide variety of rights, citizens' rights, privileges that citizens are supposed to enjoy, but those are on the black papers. They are as they come. They are not what they are in reality. Now, why is it not justiciable? Because that chapter 2 tends to hold the government and the persons who are given leadership positions into account. And now it has been made non-justiciable. It affects the generality of Nigeria. If that chapter 2 was functional, it would have given the citizens the ample right to checkmate every actions that are being done by their leaders. Citizens who have rights to question things that are done, things that ought to be done, and things that should be done. But the entirety of the chapter 2 as it operates has been left redundant, and they are just black letters that are there, beautifying our constitution. Now, why was it put in the constitution in the first place if the courts cannot boldly interpret it to be justiciable? Why was it included in our constitution? We keep on having constitutional issues and the rest. Now, if you go to the pages and sections of the 1999 Constitution, you get to find so much conflict with the realities of the rights and what Nigerians should ought to expect.
Mr. Kelechi,
yes.
Please, if you can summarize so we can take questions from other listeners. Thank you.
Okay. In summary, I would say, as much as it is almost impracticable to get a constitution within a civilian regime. You all know what happened in 2014, where we gathered people who came in for jamborees and the rest. But however, it is worth trying. It is for us to try again. If it entails calling for constitutional conference, we should call for constitutional conference and let those who will now be nominated into those constitutional conference committee not be politicians, as it were. We had in 2014 grade A politicians going into the conference, disagreeing on almost all facets of their communications and contributions. They ended up not coming up with anything tangible. So if it warrants us calling for a better constitutional conference, and the constitution of the committee for the constitutional conference should be more people who are much more younger people and more persons who are much more inclined to getting the system work. I will use my mic at this moment.
Thank you, Barrister Kelechi. I have a question for the next speaker that comes up to speak. Chairmaker, while you wait for your signal to settle, I'll yield the mic to Barrister Juliet. But if you can answer this question, please. The chapter 2, as we're looking at that, it looks broadly as the foreign policy, whatever it's meant to mean, in the light of what Nigeria actually is projecting. Now, we had a situation whereby the president asked for permission to go to war and the National Assembly has said no. But now you've got a situation where ECOWAS, in the name of a standby force, is now sending military into Niger. What is the implication for this in terms of how should the constitution, or how does the constitution handle this? Is there a repercussion for the president in trying to disobey, as it were, the mandate given by the National Assembly, even if he's coming under the guise of ECOWAS standby force? And any other contribution you'd like to make? Those are my questions. Thank you. And Barrister Juliet, you have the mic. And any other person who has a question, I will bring you up. And please, you'll be required to just say your question. Thank you.
Okay. I think I'll still aid myself with the Constitution to actually give more point to that question. But first of all, let me just say what I intended to say before I actually talk about the issue of us going to war. You know, the question about I think it was Unduka that says, why are there no institutions apart from the police waiting for instructions from above, empowered to carry out immediate prosecution when court judgments are made? Now, there are two questions here. Prosecution is different from sentencing, conviction, and all that. So prosecution is within the purview of the police, and that's where their right ends. It doesn't go other than that in terms of judgments. After that, sentencing. So theirs is to actually prosecute aside the AG and all, or private prosecutors who are actually who gets fiat from the Attorney General of the Federation. Then now your question with relation to who carries out, that's who executes court judgment. Actually, after sentences are done, we have the correctional facility. So, for instance, if the person is sentenced, convicted, they're actually the ones to actually take possession of the person. So either the person goes to the prison or serve jail term. Then if it's for conviction, what we call it now, judgments with regards to civil rights and civil claims, those ones actually can be executed by the sheriffs and all that, and then you report back to the court. So the police has no business when it comes to civil matters. The police has no business afterwards, conviction and sentencing, because the correctional departments are in charge of that. In fact, army does not even come close to when it comes to conviction and all that, because there are bodies related to conviction and sentencing. Then with respect to the question, in fact, there were so many things that came up where I just wanted to say, talk about. One of the issues is that I think our activists have not really played a good role, some of them, when it comes to educating the masses. They say the last election, because some were affiliated to some political parties, you say top to bottom. I still have a problem, and I feel they did a disservice to the Nigerian people, some of them. You say top to bottom. You were not even asking for the qualifications of those who were actually running under political parties. And this has actually made the Nigerian people so ignorant of actually the laws. Sometimes you know that your political party, even if they have the best presidential candidate, may not actually mean they have the best National Assembly members. And because of this interwovenness between the three arms of government, you end up roping a president's seat, a legislative seat together. At the end of the day, you now make them marry the executive, and at the end of the day, they start performing roles that actually are not within the constitutional framework. I think some going on, we need to start reorientating our minds. If you are active in the space of political engagement and civic education, I think it's high time we tell the people what they should look out for. It's not all about political parties, because a lot of people ride on this political system, especially people that are aged parents, people that do not even know what to do. They just end up voting in and out, because at the end of the day, people who should frame our constitution, people who should make laws or review and amend them, they have to be people who are upright and should actually do the needful. In fact, Section 7 actually comes to mind, because it's part of the things we've reviewed, Section 1 to Section 31. And I'm surprised we've not had questions relating to Section 7. And Section 7 talks about the system of local governments in Nigeria, and it actually creates a room for democratically elected local government. Nigeria has seen over since 1999 the system of caretaker committee. How come people in your various states have not actually sued your governors for actually putting caretaker committee and not enforcing INEC, your state INEC commission, to actually get the local government to have empowered people who can actually legislate in the local government level to make sure the people start seeing governance at that level. I think the absence of this has actually made Nigerian people so lackadaisical. They just, in fact, I will tell you in this space, I'm even now very scared to call myself a politician, because I will tell you why. My experiences will actually be the same experiences why a lot of people play activists and prefer not to go into politics. And I think at this point, it's better to even stay at the four walls, educate people, and even go into politics, because we've actually ended up taking all politicians, like we say, all politicians are the same. So then who then goes to actually actualize these functions of the constitutional review? Who do you actually then elect? So it's better to just stay at the front, preach to people, whoever that is bold enough, go there. If you're if you're good and decent enough, try as much as possible to put your voice out there, but you cannot do it alone. And that's one thing Nigeria has to understand. One person cannot change our constitution. We have 19 northern states. We have 5 eastern states. We all see all this unevenness in terms of our makeup of the National Assembly and all that. How then can you have a possible constitutional review? I think these are some of the questions that bring to mind to tell us why a lot of things have been going. Some of the issues have just been passing by without having solutions to them, because some of these people are either loyal to their zones. They will not want to take up constitutional debate with respect to some of those zones, and this has actually stifled Nigeria's progress. The constitution as it is today does not actually represent one tribe. It keeps on saying that we, the Nigerian people, no Nigerian is more Nigerian than another. And so when you see some states, they do not do the needful, it then comes to mind that what then are we doing? What is the way forward? Unevenness in terms of our national assemblies, unevenness in terms of our Federal Character Commission, unevenness. And we've seen the debate that has been on the floor with respect to the Federal Character Commission. So it's even part of things that we are to review. But as we go on, I hope questions come on the space. We can actually put out questions, even if these questions don't come on, or we can take it bit by bit. What questions relates to Section 1, Section 2, Section 3, so we don't actually go amiss. Then with respect to the issue of the war, and if there's a sanction going to be for if Nigerian goes with ECOWAS, I think, like I said, I would still look at the constitution and still get some point to actually talk about it. But the legislators, the president can actually go on, but must actually seek. I think he has to seek go ahead from the legislators. Then in the situation he goes on without getting their permission, I think there are certain things that we have to talk about. But let me just go through, then I can come up, because that question took me aback. I'll go through it and then see what is actually possible for Nigeria to actually make sure that the government does not go against its people to actually wage war that the National Assembly have not actually approved. Thank you.
Thank you so much, Barrister Oluchi. I wanted to go ahead and call on Wayemi. We do have. Sorry. Can you hear me?
Sorry. If you can allow me in briefly, I have limited time left. If I can take a few minutes before Wayemi or Baron, please. Can I?
Okay. All right. Go ahead. All right.
Yeah, some profound issues have been expressed here, and 2 brilliant questions have been asked. Let me start with the first question in respect of prosecution and execution of orders of court. My takeoff point would be where Ugo left off. Ugo used the phrase political culture. I will add to the phrase that Ugo used and add what I describe as political socialization. What we have of how governance is ordered and how governance is organized in our country is poor political socialization. Yes, this, the internalization of poor perception of how power is arranged and how power is organized. And when we have this poor perception, people who we endow with power, into those quarters of power and begin to exercise. We'll go into the quarters of power and exercise powers in a manner that puts him as not first among equal, but as somebody who is above all equal. That's why we have an IGP, Inspector General of Police, who is charged by the Police Act 2020 to
Great Oracle, your
exercise
connection
powers
is
of prosecution
your connection.
with permission for
Great,
his grant. Can you hear me?
Great Oracle, your connection is very it's uneven, so we are losing a lot of the words you're explaining.
Okay, can you hear me?
Yeah, we can hear you now, but try again. Hopefully
Yes.
it will
The point is, we're dealing with poor political culture. We're also dealing with poor socialization. What I mean by poor socialization is this: people internalize power in a manner in which power is not ordered and arranged the way it should be as it relates to governance. You have individuals who are politicians who go into power, politicians who go into quarters of a governance with the poor perception been endowed by those powers that they can exercise in a manner in which they privatize power to the exclusion of all others. And that's why you have an Inspector General of Police who is charged by the Police Act 2020 to exercise his powers, but waiting for the body language of the president for him to exercise those powers that have been donated or gifted or granted to him by law is a fundamental problem. When we have poor political socialization, what emerges is poor political culture, and that's the problem we're dealing with. And in terms of execution, and also in terms of, I want to say,
Yeah, the Great Oracle, I think your line is breaking up.
Great Oracle, the line is really very bad.
Well, let me try again by going to the second question. If you have the permission or non-permission granted by the National Assembly, whether or not to go to war in Niger, I think we have the guidance of the Constitution here. From the top of my head, Section 5, subsection 4 and 5 of the Constitution. Section 4, subsection the National Assembly, more specifically both arms of the National Assembly, granting permission or non-permission to the president to go to war. And subsection 5 talks about, the president may go to war on the basis of advice given to him by the National Defense Council. And under that subsection 5, if I recall correctly, there is within that period of limited deployment of combat forces, the president must take permission from the National Assembly. The question that must be asked here now, if you're hearing me, is that has our National Defense Council met to give any limited approval to Mr. President? Mr. President does not have absolute powers to send Nigerian men and women to war on the basis of 5 of our Constitution. The international law here, the Treaty of ECOWAS, and I'm struggling, maybe lawyers will help me. Which of the treaties of ECOWAS grant member state powers to invade other countries? I've looked at the 1975 treaty. I've looked at the revised 1993 Cotonou Treaty. I've not seen any specific article they're doing. The status of forces agreement that they rely on, as far as I'm concerned, on the basis of Section 12 of the 1999 Constitution, has not been incorporated into our municipal law. So our president cannot go to war, either as part of the fighting force of ECOWAS or as a nation. That is my point. Thank you.
All right, thank you so much. Thank you so much, Great Oracle. Wayemi, you can go ahead and read the question from the comment section.
Oh, thank you, Kwame. That was what I was trying.
All right. Good evening, everybody. I trust we're doing well. Let's take some questions quickly. The first question will be, So this question says, Chapter 3, subsection 28, into bracket 1, confuses me. To forfeit means the applicant won't be the citizen of the country he's from and only Nigeria. The personally shall identify with. I'll take that again. Chapter 3, subsection 28, in bracket 1. I'm sorry if I'm not pronouncing that well in, law terms. So it says, subsection 28 in bracket 1 confuses me. To forfeit means the applicant won't be the citizen of the country he's from and only Nigeria. The person shall identify with. That's the first question. And then the second question says, hold on, please. This person says, why is there no constitution apart from the police who will be waiting for the instructions from above, empowered to carry out immediate prosecution when court judgments are made and such
Oh,
institutions be held?
we have answered that question. Go to
Okay,
the next
so
one. Yeah.
Okay, so this one says the Macpherson Constitution of 1951 is the best constitution to have been suited for our policy because of our diversity. The imposed 1999 Constitution of the Federal Republic of Nigeria is a fraud. So I will leave it at that.
If our panelists can just please address the questions in as brief as possible to allow I think we can ask David to have a go at this one, this one briefly. Then Baron can address the second comment. Thank you.
Sorry, I'm not sure I heard the question. Sorry, I'm just multitasking here. If the question could be asked again, so I could address it.
Wait a minute, please ask.
All right, no problem. So the first question is this. Chapter 3, subsection 28(1) confuses me. To forfeit means the applicant won't be the citizen of the country he's from and only Nigeria the person shall identify with. So that the person is asking that, okay, chapter 3, subsection 28, into bracket 1 confuses them, saying that to forfeit means the applicant won't be the citizen of the country he's from, and only Nigeria is a country that the person shall identify with.
Well, it's a very simple question. The laborious way you went about the Constitution is referred this way. Section 28, subsection 1 of the 1999 Constitution. It talks about, on top of my head, it talks about dual citizenship. But if you look at the preceding provisions of the Constitution of that chapter 3, particularly section 25 and section 26, it talks about citizenship by birth and citizenship by registration. So if you place both sections 25 and 26 on top of your mind as you look at 28, what 28 says is that Abdul Mahmoud, who is a citizen of Nigeria by birth, if he chooses to acquire the citizenship of United Kingdom of America, by the operations of section 28(1), I cannot lose my Nigerian citizenship by birth. In effect, section 28(1) is saying that those who acquire Nigerian citizenship under section 26(1), which is citizenship by registration, if you acquire another citizenship other than the citizenship of Nigeria, you lose that citizenship of Nigeria that you have by registration. That's what it means, simply stated. Thank you.
Okay, sorry if I could just. Sorry, I'm just multitasking here, but I think a great oracle has said what I should say really. Basically, just even for more clarification, every Nigerian citizen that was born in Nigeria cannot lose their citizenship, whether or not they take another citizenship. They cannot lose their citizenship. So if they were born in Nigeria, they cannot lose their citizenship, period.
No. You are already creating a problematic when you use the phrase "born in Nigeria." I have 3 kids I never had in Nigeria. I had them in the UK when I had the opportunity of going for graduate studies, and I made them Nigerian citizens. The mere fact that I enjoy citizenship by Section 25, subsection 1 of the 1999 Constitution. The Nigerian citizenship cannot be denied them simply because they were not born in Nigeria. You understand? Don't create a new problematic.
Yeah, I think Baron.
Okay, Baron, if you want to comment on the second, the second question, more or less like a statement that you read.
Yeah, it was more or less like a statement, but I will take it again. So it says, please hold, let me go back. Okay, no, let me take this one instead. So this one says, I really would like to know how we can coerce the NAS and the executive to review the 99 Constitution. Whenever I ask, the only feedback I receive is that it's not going to be an easy thing to achieve. We all know the Constitution is fraudulent. How do we easily review it?
So, Baron,
Okay,
if you
thank
want
you
to
very
take a slice at that, thank
Yeah,
you.
thank you very much. Let me just add one thing to what the great oracle said in terms of citizenship by birth. So I think the Nigerian Constitution creates citizenship by birth, and there are 3 categories: those whose parents were citizens and those who were born in Nigeria. I think those one of their parents were citizen by birth. For example, I wasn't born in Nigeria, but because my parents are Nigerians, I am a citizen of Nigeria by birth. So let me take the issue of this particular question that Wemi has somebody has posted and Wemi read. Now, I think it goes to tie on to what I was saying earlier before I got kicked out. I think somebody who was blocked or some got into. So now, I see a problem us trying to set up a constitution drafting committee or review committee, because of course many people will come into that committee to try to champion regional interests, religious interests, as we saw in 2014. Now, where is it going to be an exercise that is possible? I doubt that, because Nigeria is deeply divided in ethnic line and religious line, and then arguments will go all over the place, and it will quite frankly practically impossible to actually do anything about constitution. That brings me to the most potent solution which I was talking about earlier, which I think it is behest on our judges to now start to interpret our constitution the way it is supposed to be interpreted. So why is that important? That's important because when they go back to our principle, our founding principles, I was saying earlier in the case of Rose versus Wade and the case of the Indian Supreme Court, they begin to bring our constitution live. Are they going to do it? Yes, over time it's going to be possible. But do I see the way? Is it practically possible to set up a constitution drafting committee or review committee to look at the constitution as a whole and make headway? It will be difficult, because then groups will come and argue that they are not properly represented. And so I think our courts, in particular, our Supreme Court, must bring our constitution to life, move it into 21st century, and that's what I think they can do. So to me, I'm not convinced we can set up a constitution drafting committee to review our constitution because of our Nigerian nature. Thank you.
Okay, wait, do we have more questions on that? Whilst we are reading the question, I think let's give Oink an opportunity. She might have a question. Wait, while you scoop up some of the question. Oink, do you have a question?
Yes, I do.
Please, you have the mic.
Yes, I do. Actually, is in the comment section. But I want to say good day to everyone, host, co-host, and the panelists, and of course, those listening. And this is where I'm at this point. Again, well, questions. Okay, I don't want to I don't want to channel you guys to a certain area, but I feel, yes, this space is very, 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 very relevant, and it's good to discuss this. And I'm just wondering, can we do a deep dive on the rights of citizens as it is in the present constitution? Yes, our constitution needs to be reviewed. We need amendments. Can we discuss in basic English, not lawyerly terms, the basic rights of citizens? For instance, in the US, we have the right to free speech. We have the right to religion. We have the right to freedom of the press. We have the right to assemble freely, and the right to petition the government when we have issues. Can we know those rights, and can we discuss it again? I want us to do a deep dive in a way that the ordinary citizen listening would understand it and we can benefit from it, especially now. And basically, for me right now, I really want to know about the right to freedom of assembly and how to petition the government as it is now.
Okay.
Thank you.
Okay, thank you, Oink. I'll call Kelechi, Barrister Kelechi, to have a bite at this question. Thank you.
Okay. I think going by her question, she intends for us to look at the holistically the fundamental rights available and maybe other rights that are alienable to citizens. Now, by my understanding, I think we'll be going off board of what our discussion today is. When I had discussion with the chief host, he told me we were only limited to chapter 1, 2, and 3. Now, those rights that we are looking at will be at chapter 4. That is the next, and we've not gotten to that part. We've not learned that part, except we want to discuss it here now.
That's good enough,
if
sir.
we want
that
to discuss
answers
it here
the
and now, then
question.
Yes,
Sir,
and then
I think we should restrict ourselves to what we are
yes,
dealing
we
with
should
today.
stay with the topic, host.
That's okay.
Kelechi,
That's okay for me.
you have, but we will deal with it. We will deal with it. Don't worry.
I believe we are. This is not the last time we're going to have this discussion.
Not at
I
all.
think we can move that to the next discussion, which by that time the chief host would have posted it on the general platform. Everybody will get a feel, and then we'll have this discussion, because it will be premature for us to start discussing it right now and abandoning the introductory paragraph of introductory chapters 1, 2, and 3 that we are still handling. It will be doing a disservice.
That's great. That's okay.
I think what I would say,
but can I say something? I think we still have some rights in chapter 2 which we can even discuss, although they are not justiciable. So please let's let them answer it with respect to chapter 2. There are some rights contained.
If we cannot, that's okay with me. And is my initial
there are
OIK, not OIK. Excuse me, Liberty.
OIK.
That works with me.
Okay. Listen, OIK. Listen. Mute your mic kindly, please. What's happening is that we've got your question. Now the panelists are reviewing it to try and address it within the remit of the topic we have at hand. So let them look at it. And if there's anything more that we can't fully expand on, we will carry it over to when we actually look at it. So Barrister Juliet, you said there's something in chapter 2. So please expound,
yes.
or Barrister Kelechi expound on that for OIK.
Okay.
Thank you.
Okay. There are, just like I said the first time I spoke, the chapter 2 is a decorative sections that are attached to our constitution. What do I mean? Then be like saying, now waiting follow come. They don't really help anything. As then be. Now, there are sections of our constitution, they are, as much as they are beautiful, there are rights that are there. But those rights cannot be legislated, they cannot be adjudicated upon by a court of competent jurisdiction. What do I mean? If you carry any matter where those sections, that chapter 2, any of those rights in chapter 2. Now, in that chapter 2, you see rights to education and all those other rights and the beautiful things the government are supposed to provide. Now, it is beautiful, and it like I said in the first time I started, I said if we were to hold the government accountable, the best option to go is by chapter 2. But our court has said that chapter 2 cannot be, we cannot go there. It is a beautiful nonsense. It's not something we can go into and come out with our heads. So basically, as it stands now, in chapter 2. Now, part of what is in chapter 2 is we have what we call the fundamental obligations. These are the obligations that are that the government wants to undertake for the citizens. You know, they must in their actions and in their provisions reconcile themselves within these things. These are things that the citizens must enjoy. As the word says, the fundamental obligation of government. They are something like schools, amenities, road, electricity, blah, 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 and all the rest. They are fundamental obligations of government. But now the courts and our constitution is saying it is not, we cannot hold our leaders accountable by these facets. So now we have the government, section 14 talks about the government and the people. This is supposed to be like a connection. How do I put it? Something, obligatory things. The something the government owes to the people, and in connection, the people reciprocate to the government. Well, unfortunately, within this section 13 to section 24, there are the rights are there. We have section 15, we have the political objective. 16, we have the economic objective. 17, we have the social objective. 18, we have the educational objective. 19, the foreign policy objective. 20, we have environmental objective. Now 21, we have directive on Nigerian cultures. Now 22, we have the obligation of the mass media. 23, we have the national ethics, and 24, we have the duties of the citizen. Now, in summary, now this section provide for all these policies, and they are supposed to be the working document. The thing the government is supposed to draw inference upon their contributions and whatever they bring to the people. But now it is not fundamental. It is not something that you can hold them accountable to. The rights are there and they are beautiful, but the court says you cannot hold the government accountable by these rights that are in this chapter 2. I will yield the mic for another of my colleagues to throw more light.
Thank you very much. I'm very aware we are about rounding up on this, host, but we're not on this space, but we're not yet. Please, host, indulge me. Let me allow Osaro in 1 minute ask his question because he's been patiently waiting, and then we can go into the trivia you have to round up this space, and then our guests can summarize on any other aspect that we've omitted. So, Osaro, you have the mic, please, quickly, if you have a question.
All right, thank you, Liberty Champion, host, and Peter Obi, Grassroots Mobilization. Thank you to every speakers and listeners. My question will just be simple. It's going to be like, I want to ask the panelist, is the 1999 Constitution truly a constitution or a military decree? That was one. Then secondly, what was the meaning of federal character and how is it being practiced in Nigeria today? Thank you.
Okay, thank you very much. Let me see who is raising their hand. Ugo, do you want to have a? Okay, Byron. Permit me, Ugo. See, Byron, because you've been dropping, would you want to have a slice at that, please? And if you drop out again, then Ugo will.
Can the question be read again, please? Sorry. Thank you.
Osaro, can you ask your question again, please? Byron didn't catch it.
Okay, the question is this. Is the 1999 Constitution truly a constitution or a decree? And secondly, what is the meaning of federal character and how is it being practiced in Nigeria today? Thank you.
Okay, thank you very much. Let me see who is opening, raising their hand. Ugo, do you want to have a? Okay, Byron. Baron, did you catch that?
His line was breaking. I know that.
Okay,
Let me rephrase this question. The first one is that is 1999 constitution can truly be called a constitution, but the other question is what I didn't get.
Okay, the questions are: is the 1999 constitution a constitution or a military decree? That's question one. Question two: what is the federal character right now, and is that truly being practiced in Nigeria? I think that's me paraphrasing. That's like what he asked. Can you hear that? So over to
Yes,
you,
of
Baron.
course. The nomenclature, the document that we call 1999 constitution, of course, it's a constitution, but though it was put out by the military guys when they were trying to go out, we must also understand and take into consideration the history of Nigeria as at that time. But before or why they were trying to push out the military to ensure that democracy could start. That it is. It is a constitution, but can we say it meets the requirement of the people constitution? No, those arguments are quite clear because, of course, there wasn't a referendum, the people were not consulted, and a whole lot of it was not done before that constitution was drafted. So it cannot be said to be the people's constitution, but it is the Nigerian constitution. The other question which you talk about is that, please, Liberty, can you remind me again, please?
What is the nature? What's the federal character that is Nigeria currently? The constitution, the federal character, is that in practice right now in the current Nigerian polity?
Yeah, the whole idea of the federal character was to do integration to ensure that people are properly represented. But I am not convinced, based on what is happening in Nigeria, that federal character is actually being implemented on the basis of the intent of the constitution. Are we going to change it? No, but I do not think so. So because it's not functioning, and because I don't think this was what the drafters of the constitution intended, what is happening at the moment, I think we need to take a different approach, and that approach will be the approach of not having tribes and states and so on. Wherever you are born, that is where you can claim that's where you are. We should have one Nigerian nationality and not this whole thing about tribe. I hope I've been able to answer. That's the best I can give, to be honest. Thank you.
Thank you very much. I know, Barrister Juliet, you might have a contribution. Sorry, Hugo. I just want to make sure those who have not spoken. Descars, you've been on the speaker. Do you have any comment or question? So at least you're not... Descars? Okay. Ugo, do you want to have something to add? Then we'll go to Barrister Juliet, then David, briefly in 1 minute, then we'll go back to the host. Ugo.
I'm happy for Barrister Juliet to go first, if that's all right. Yeah, I'll speak after her.
Barrister Juliet, is over to you. You've got the mic.
No, I think, okay, I wanted to say he should go ahead, but it's okay. So I wanted to say, with respect to the Federal Character Commission, we have it in section 14.3 and section 318. So now, what is a federal character? It refers to distinctive desires of the people of Nigeria to promote national unity, foster national loyalty, and give every citizen of Nigeria a sense of belonging to the nation, as expressed in section 14.3 and 4. Now, section 14.3 and 4 says the composition of the government of the federation or any of its agency and the conduct of its affairs shall be carried out in such a manner as to reflect the federal character of Nigeria and the need to promote national unity and also to command national loyalty, thereby ensuring that there shall be no predominance of persons from a few states or from a few ethnic or social sectional groups in that government. Now, with relation to Nigeria's Federal Character Commission, it's the one actually established for promoting the objectives of this provision. Please, I hope my words are still simple enough. So now, in a situation that this does not work, whereby we have 37 states, right? Though we know we have northern states in high numbers than other states, but we should make sure that all ethnic groups. So now, if Nigeria has a total of maybe 400 or how many ethnic groups, or we should make sure that in every agency we should have every composition of this ethnic group, because it was even stated that it included states, because you can have somebody from a state. For example, I'll use Edo State. You can have Edo State, but the ethnic groups are different in Edo State. We have people from various parts. And now when you just see, they tell you one person from Edo State has been employed in National Ministry of, Ministry of Foreign Affairs. It's wrong. You have to make sure you encapsulate every ethnic group in Nigeria. And this has not been the reality of things. You see, when recently there was an investigation for as regards to the federal FCC, we saw how there is now racketeering of jobs, and this has gone on nepotism at its highest in the past government and even the present government. It is high and alarming. I think even if Chapter 2 is not justiciable, it's the right of every Nigeria, and that is why we're using the media today, because the media today is one of the highest from the body that can actually call for certain things to actually be put in the right place. And even if you say Section 22 says the press, the radio, television, and other agencies of the mass media shall at all times be free to uphold the fundamental objective. So it's our responsibility to make sure that even if these things are not justiciable as regards to Section 6, which talks about the judiciary shall not entertain things in this section, this chapter 2, 14 to 24. But what we're doing right now is necessary for the people to now rise up and challenge the system on why the Federal Character Commission is making sure few ethnic groups or selected ethnic groups are in the Federal Character Commission. And for me, I would say this, with the composition of the Nigerian parastatals, I do not believe the federal character has not been truly reflected in Nigeria. I think that's what I wanted to say.
Thank you very much. David, I know you want to come up. I just want to give any other person an opportunity to ask question. OIK, do you have any additional question before I pick from the statement? And if you finish asking your question, if you kindly drop down, the host has kindly allowed us to extend to 5:30 so others can come up and ask questions to the panels. Thank you. OIK, you have the mic.
Thank you. My question, I don't think has been answered, and I didn't ask that question just for my benefit. I wanted to benefit everybody listening here, because it's important that we know our rights in terms of the Constitution as it is, even though we know that our country is so faulted that there's nothing we're following, but at least to know in terms of where we're at right now with the movement. So again, I would like, maybe next time you guys meet, you're going to be on Section 4 of the Constitution. We can talk about the rights of the citizen with regards to assembling or having to show disapproval of the government, as a people, collectively or individually. I would really like to know. And when it comes to arrest, what is done and what is not done, and all in that light. Briefly, I just want to shout out to Osara. Osara, sorry, my DM is not working, okay? I'm getting it working. I will be in touch with you. I actually sent you a private tweet. Check your private tweet, okay? Sorry. We'll be in touch soon, maybe before the end of the day. Thank you. Thank you, everyone.
Thank you, OIK. Thank you, OIK. If you kindly drop to the listener section, please. Thank you. And I'll give Ugo and David an opportunity to react to OIK. Even if we're not dwelling into it in detail, if you just want to kind of skim over it, that is fine. If you can do that 2 minutes each so we can take more questions, because we have new speakers up here. Thank you.
Okay, thank you. I want to briefly, I'm going to make 3 brief points because I want to comment on the issue relating to Chapter 2 of the Constitution. So basically, the Constitution is subdivided into several chapters. So chapter 2 of the Constitution is referred to as the chapter containing the fundamental objectives and the directive principles of state policy. What that essentially means in more simple terms is that it has to do with the values, the philosophy, the ideas that we subscribe to as Nigerian people. These sets of values form the background to our government, the way we want to organize our government, our way of life. Lawyers have typically described that section as non-justiciable. What that means is that when you say that a provision of the Constitution is justiciable, the meaning of that is that you can rely on that Constitution as a basis for litigation. You can go to court to enforce a right contained in a justiciable section of the Constitution. But if the Constitution declares that a certain provision is non-justiciable, it means that you cannot rely on that particular section as a basis of legal or judicial enforcement. One of the reasons why that particular chapter has been made non-justiciable is because in terms of legal theory, many of the rights contained in that chapter are very resource dependent. They require very heavy financial commitment on the part of the state. So, for instance, Section 17 is one of the non-justiciable provisions of the Constitution. It says that every Nigerian has the right to ensure that, there is, and I'm simplifying now, that the exploitation of the natural resources of Nigeria shall be for the good of the community. Another example in that chapter says that the Nigerian state shall ensure that every citizen has opportunities to secure adequate means of livelihood and adequate and suitable employment. You know how many unemployed people there are in Nigeria. If that section was made justiciable, in theory, every unemployed person will be able to drag the state to court and say, well, the Nigerian state has not fulfilled this provision of the Constitution because I don't have suitable or I don't have adequate employment. So that's one of the reasons why that particular, those provisions in the Constitution have been made non-justiciable. Another example would be the Nigerian state has a duty under that chapter to ensure that every Nigerian has opportunity to access free university education. But again, if you don't have university education, if you can't afford university education, if that provision were to be made justiciable, you would have a right to approach the courts to enforce that duty on the part of government. So it's a very complicated issue. I think that we should devote ideally a particular space to discuss the provisions of Chapter 2 to really understand and to dig deeper into what those provisions are. Now, the second question I want to address is the point about the nature of the Constitution. Yes, as some of my colleagues have also pointed out, the 1999 Constitution is a constitution. It was enacted initially in 1999 as a decree of the outgoing military government headed by General Abdulsalami Abubakar. And that's why many lawyers have attacked, not just lawyers, commentators. There's a brilliant paper by a political scientist, I believe, Professor Julius Iyonvere, who has, if you are interested in reading up in greater detail about the 1999 Constitution, he examines and discusses comprehensively the manner in which, the undemocratic manner in which the 1999 Constitution was enacted. The people were not carried along. There was no referendum. We didn't even know what the provisions were. It was essentially imposed on the Nigerian people by the outgoing military administration. But I want to also enter a note of caution because I think that there's another way to think about the Constitution. So constitutions can acquire legitimacy through the process of their adoption. So if in making a constitution we carry everyone along, there's consultation with the people. This was one of the methods adopted in drafting the 1979 Constitution. After the Nigerian Civil War between 1967 and 1970, the country was broken, was divided. Millions of people had perished in the Civil War, and representatives of the Nigerian people came together in a constituent assembly to write a new constitution for the people. The understanding was that part of the reason why the First Republic collapsed by a bloody coup d'etat in 1966 was because of certain defects in the 1963 Constitution. So when Nigeria was making a transition to the Second Republic, we are now in the Fourth Republic. The military regime at that time, headed by Murtala Mohammed and General Olusegun Obasanjo, as he then was, they decided to set up a program, a democratic transition program. So Nigerian representatives in a constituent assembly came together and they drafted the 1979 constitution. Our 1999 constitution largely is modeled on that particular document. But the problem with the 1999 constitution was that it was promulgated by the military administration. There was no widespread or popular consultation with the Nigerian people. And that's one of the problems with that particular document. But having said that, a constitution can also acquire legitimacy over time. So when you look at the American Constitution, for instance, one of the longest or one of the oldest constitutions in the world, at the time it was promulgated, there was no widespread consultation. So the large sections of the population, women were not consulted in writing the American Constitution. The Black population, enslaved at the time, they were not carried along. But over time, the American Constitution has acquired legitimacy. Those people who argue in favor of the 1999 Constitution take the view that this Constitution is the longest surviving constitution in Nigeria's history. 1999 to 2023, that's a period of 24 years. It has survived for 24 years. And if you belong to that school of thought, you would argue that over time, the 1999 Constitution has acquired a certain degree of legitimacy. Of course, there are opposing views that can be put forward. But the point is essentially that we should understand that it's not just, as lawyers, one of the things we say is that when you have two lawyers in a room, you have three opinions. And it's a very useful way of thinking about these issues. There are so many different points and counterpoints that can be put forward in relation to the legitimacy or otherwise of the 1999 Constitution. And like I said earlier, and as the great oracle was saying, we also have to think about issues relating to political culture. You can have a beautiful constitution. If the political culture is problematic, that constitution will be frustrated. We are socialized, as Great Oracle was saying, we are socialized into a culture that respects fundamental human rights. Another important point I want to mention is, look at the National Assembly. How many women were elected into the National Assembly? That's an issue that has to do with our political culture as well. There was a time a gender equality bill was placed before the National Assembly, and the majority of the men, they threw out the bill, they tossed it out. There's a lawmaker who said, you want me to make a law about gender equality so my wife can start challenging me in my bedroom. That sort of backward thinking. These are issues that have to do with the fundamentally problematic political culture of the country. So it's good to think about the way the Constitution was enacted, what the provisions of the Constitution say, but also focus on the values. If we have not internalized gender equality as a value in Nigeria, we will be satisfied with a problematic situation in which the majority of the lawmakers who make laws for the entire federation are men. It's not a representative legislature because half of our population is underrepresented severely in that National Assembly. So these are some of the things that we should be thinking about going forward. The last point I want to make has to do with federal character. Barrister Juliet explained that very well. But in principle, the idea of federal character is a good one because one of the ways in which you can think about it is think about merit versus inclusivity. They are two values that sometimes collide. They're sometimes in tension with one another. So if, for instance, you have a situation where in the federal cabinet, all the ministers in the government come from a certain ethnic group or they come from a certain religion, that's not going to be acceptable to people. People are not going to feel a sense of inclusion in the government. So why the idea of federal character was actually put in the Nigerian Constitution for the first time in the 1979 Constitution, because one of the problems in the First Republic that was identified during the First Republic was that the perception was that the majority ethnic groups, the Yorubas, the Igbos, the Hausas, had dominated the government, and there was a sense of exclusion, especially from the minoritized ethnic groups. They felt that they were not carried along. So when they wrote the 1979 Constitution, one of the principles they enshrined in that Constitution was to say that whenever you are appointing people to government, the offices in government, the institutions of government should not be dominated by a particular ethnic group or a particular communal group. Try as much as possible to make the matter inclusive so that we can draw personnel from all sections of the country. That is what it means in principle. And if it is operated or implemented in good faith and in a principled way, Nigerians will have a sense of belonging and inclusion in their government. But as many of the lawyers have pointed out on this space, that's not the case in Nigeria. There's still a feeling that some religious groups or some ethnic groups have captured a majority of the influential positions in government, and that's one of the reasons why there's so much political instability in Nigeria today. So I think I'll just stop here at this point. But thank you again for the opportunity to speak.
Thank you very much, Ugo. Thank you so much for your submission and to all the speakers. Okay, this is what I'm going to do. We've got about a couple of minutes to 5:30. I know, host, you want to do your trivia. Do you want to let me give you because I think David wants to say something, or shall I just quickly round them up? David, you got a minute to make your additional contribution. I can see Benga, you're on the speaker stand. Please lift your hand up if you want to ask a question, and if not, please, I will give back to the host. David, whilst you're speaking, please, 1 minute. Benga, if you want to ask a question, put your hand up so I know. Otherwise, I'll give back to the host. David, you have the mic for a minute to make your contribution.
Well, Ugo, I don't necessarily agree with some of the points that you raised because I'm one of those who actually do not support the depart from the Nigerian 1963 style constitution to the 1979 that was fostered by the military for a number of reasons, which I will not discuss here because, like I said, this place is not the platform for it. I thought the depart from that 1963 constitution into a United States style of government is some of the foundational problems we have even till today. But I'll leave that aside. I thought my colleague was making reference to the 1979 Constitution, Chapter 328, in his submission, because the 1999 Constitution, Chapter 328, speaks of birth and establishes birth that cannot be revoked itself. So I'd like us to go look at that, at our spare time, because I think he was referring to 1970, except I missed the question, but I think his submission was referring to 1979 Constitution, 1979 Chapter 328, because 1999 Constitution, Chapter 328 speaks of birth. And it basically says that your birth cannot be, as a born Nigerian, you can't lose that citizenship. Okay, I also wanted to speak straight to the ECOWAS Treaty, Article 89 of the ECOWAS Treaty. Basically, we all know that it's a 15 membership. The ECOWAS is a 15 membership state, and they need up to 9 members to approve any action that they want to take. Of course, there are no military actions that are enshrined in the treaty itself. And most of the actions they would take towards any ECOWAS state are more of a negotiation or a support, economic development support. So I believe basically that any action that ECOWAS will take, the Nigerian state is not part of it. But the Nigerian state will just tag along because the Nigerian parliament has not approved that. Thank you.
Thank you very much. Host, I yield the mic to you for your trivia as we round up. Thank you.
Please, Liberty, I wanted to ask, can any of our colleagues talk about the issue of the penalty if the National Assembly continues to withhold their approval for going to war? I think if maybe we can learn, because where 2 or 3 lawyers are gathered, there's actually a plethora number of knowledge we can actually share.
Okay, host, what do you think?
Yes, I agree with that. I know a lot of people have questions to ask.
Okay.
We're actually running out of time, but yeah, let's
we can give it 5 minutes. Yeah.
Yes. Before we go into the trivia.
All right.
Can I come in?
Okay, Baron, over to you.
Okay, but so Julia, your question is quite interesting. So here's the thing. Once there is a mandate by the ECOWAS on members, the National Assembly cannot withhold consent. They can seek concession, but they cannot withhold consent. As I've argued, I said the president has not formally asked for approval. If he does, the National Assembly cannot withhold consent, because if they do, it will be a breach of Nigerian obligation under international law and under the ECOWAS treaty. So what they will do is that they can seek concession, they could ask for a less number of troops, they could ask for clear guidelines, clear timelines, but they cannot withhold consent. That's why it's important. So if you look at the ECOWAS treaty, you will see that the obligation of member states to ratify and give consent to that decision which is made under ECOWAS treaty. And that is how it is in most international law. Thank you.
Okay, Kelechi, I think you have a contribution to make. Over to you. Barrister
Yes,
Kelechi?
yes. I kind of disagree with Baron. The National Assembly can and will deny consent. The only thing is the ECOWAS has the right to impose sanctions or not. But if it has to whether we can or cannot deny consent, we can deny consent. Of course, we're a sovereign state and we have our own country to think after. So if such agreements are in contradiction to the principles of Nigeria, the National Assembly can deny consent, and the only repercussion that will come with is that the ECOWAS as an organization, which we all know it's a toothless bulldog, can impose their sanctions, of which most sanctions may not directly affect Nigerians, but plunging Nigeria into war simply because of an ECOWAS agreement. The National Assembly has no such obligation that they must accept everything that the ECOWAS says. Anyone that contradicts their principles, the principle of it as a nation, the National Assembly has every right to jettison such agreement and go forth with what is best suited for their country. The only obligation left for the ECOWAS is for them to oppose sanctions. Now, wherein the National Assembly denies any of this consent, the president cannot on his own, out of his own volition, send our troops to Niger. If he does that, he has conducted himself in a misconducting manner, of which such may warrant an immediate action of impeachment on the president. So I need to point out that. Thank you.
Thank you very much. David, you have something
yes,
to add?
well, I quite agree with
2
my colleague
minutes.
Kelechi, because I think Article 89 of the ECOWAS Treaty is pretty clear about what every sovereign member state position must be in relation to a joint partnership, if you like, on any expedition to any ECOWAS state. They need 9 members to approve any expedition. And for instance, in this instance here now, the Nigerian executive government needs to take approval from the parliament to make any military deployment or declare war and any of those sort. And I don't know, except maybe because I'm abroad, I don't really know what's going on. So perhaps Baron could explain to me. I thought Mr. Tinubu has made a request to the parliament and the parliament has rejected his request. Please correct me if I'm wrong, because that's the impression I had here. And from some articles I see around, and I didn't ask some of my colleagues in Lagos, that's the impression we have. So perhaps I don't know, but we thought Tinubu had made a request to the parliament and the parliament has rejected his request. So I don't understand what my colleague mean by Tinubu has not quite made a request. So I need some clarification here. Thank you.
Thank you very much. So let if you go, I think many people are arguing on the whole idea of what is in the media. Now go look for the letter that was written to the parliament. If you read it, look for it online and read it, you will see that it was not a request. It was a formal inform. I think there is a way they use that they notify the assembly. And then the assembly profile certain conditions which is to say, we have acknowledged we want other options to be explored. Now, what I'm saying, which I think Kelechi and I think David quite did not get quite clearly, I said, so here's the thing. If member states of an international treaty are independent and sovereign nations, now, but when those obligations are enacted, which if you see what happened in UN treaty in Iraq, UN treaty in Libya, then those sovereign state has an obligation. They has an obligation to ensure that that international treaty is enforced. That mandate is carried out. I understand the emotion in Nigeria that it is not needed. But if you give Nigeria the opportunity, if Mr. Tinubu makes formal request to the National Assembly, I can stake money on it. I can tell you in all honesty, the National Assembly will not reject that request because it will be a breach of their obligation under international law. So do they have the power? Of course, if the Constitution say you must seek permission, it means that the Constitution, the National Assembly has the power to reject. That's not my argument. My argument is that the National Assembly will not reject, because if they do, it's a breach of their obligation under international law. That's my argument. My argument is not whether they can or cannot. Of course they can, because if that mandate is supposed to be sought, then there is the option of rejecting or approving. But I think if you're in the UK, you will understand what I mean. The Human Rights Act and national legislation. Human Rights Act is interpreted in such a way to give effect to national legislation, even when it is not convenient for national law. I think that's the type of thing that I'm saying. The National Assembly is under an obligation to act in a way that does not breach Nigerian obligation under international law. Thank you.
Thank you, Chamika. Ugo, you have a contribution in 2 minutes, please. Thank you.
I agree and I disagree with my learned colleagues to a certain extent. I think that yes, you're right. On one hand, to argue that the National Assembly has a duty to ensure that Nigerian laws are interpreted in a manner so as not to contravene our international obligations. I mean, as a responsible member of the international community, we don't want to be seen as breaching our international obligations. But on the other hand, you remember the Supreme Court decision in Abacha and Fayemi in 2000, where it was said that no international treaty will override the express provisions of the 1999 Constitution. And so if the Constitution gives the National Assembly the power to actually approve or disapprove a request to wage war against another country. If the National Assembly determines that such a war is not in our national security interests, remember the phrases used specifically in Section 5 of the Constitution, it would be unconstitutional for the president to violate a resolution of the National Assembly rejecting his request. And I also take the view that if he goes forward to wage war in contravention of that resolution, he will be committing an impeachable offense. And in a serious democracy, if a president defies the National Assembly, wages war without legislative approval, he should be impeached. The machinery for impeachment should be set in motion against him to force him out of office. That's the view I hold. I also want to just quickly respond to some of the points you made, David. I agree with you to a certain extent, but I also disagree. I think that we should be careful not to romanticize the 1963 Constitution. Remember that many of the problems we saw in the First Republic, the collapse of the First Republic, the subsequent Civil War, the very cumbersome procedures for creating new states under the 1963 Constitution were responsible for the failure of that Constitution. So whilst you're right, there were certain redeeming features in the 1963 Constitution, I don't think it's necessarily a panacea to the problems of Nigeria's current constitutional framework. I'm not an apologist for the 1999 Constitution, but the point I was making was that we should look at different views, divergent viewpoints with respect to the strengths and weaknesses of that particular constitution. If you say entirely that this constitution is totally illegitimate, should be thrown in the rubbish heap, there are also drawbacks to that kind of thinking. So that's the point I was making. We should be very careful about not romanticizing some of the previous constitutions we have operated in our history. Thank you.
Thank you to all our panelists. I'm sure our listeners, we have really gained so much. Now, Benga, some of us here know who you are. Please, you give me an emoji. Are you going to ask a question? We don't have any space for you to make a submission. Can you give an emoji if you're asking a question? Benga, can you give an emoji if you're asking a question, please? Okay, you don't have a question to ask. Host, is back to you, please. Thank you. Oh, you have a question. Okay, please ask your question in 60 seconds. Thank you. Benga, ask your question in 60 seconds. Thank you. Can you hear me, Benga?
Hello, can you hear me?
Please ask your question.
Yeah.
Your question in 60 seconds. I'm sure you've heard everything happening. So this is apolitical. We are here to learn about the Constitution.
Okay.
Ask your question. Don't rile anybody up. Thank you.
All right. Thank you. The host, chief host, panelists, speakers, listeners, everybody. Good evening to you. Yeah, I have this question. I want to ask, is there a section or a portion of the Constitution that energizes you as an individual to intimidate, to blackmail, to cow chief justices or justices to carry out a particular action in
Benga,
your way?
Benga, your question is actually a leading question. It's not actually a question. Can you please ask? Listen, I'm not a lawyer, but I can answer the question. Shall I answer the question? There is no part in the Constitution that says any Nigerian citizen should blackmail what have you. So that you have the answer to already. Do you have a serious question you want to know about the Constitution? Not something that even me can give you an answer to, that our lawyers can really, really speak to. Don't waste our time here. You either have a serious question or you don't. I've told you, do not rile anybody up. I'm not going to give you that chance.
Honorable
But if you want to ask a very intelligent question, ask it now.
Honorable
If you don't want to ask, just mute your mic. Thank you. Mute your mic, please.
Honorable.
Thank you. Host.
Yes, I want to use this opportunity to appreciate everybody for coming out. We have learned so much today. Baron, I see you. I see your hand up. Before we come back to you, I wanted to let our listeners know that so far we have studied from chapter 1 to chapter 3. And based on all the chapters that we have looked at, there will be a trivia. And I will let the scars talk about the trivia. So the scars, you have the mic.
Hi, thank you everyone. I've been listening. It's been very interactive. Thank you all the guest speakers for being here. And thank you the host for putting this together. I guess this is a way forward for Nigeria. And I just also want to suggest that everyone here, we should all look at this topic from the angle of our right as citizens, our expectations, and when to speak up when the things are not going in accordance to the Constitution. Right. So I would just go over the questions that we'll be asking for today. And just to let you know that the first 30 people will be getting data sent to them. So please, and you know those things happen with fastest fingers. So if your fingers are not ready, get your fingers ready and we'll start counting from 60 seconds, 60 seconds, 59, 57. I'm going to put the tension. So, sometimes even when you type it wrongly, that means you've lost the answer. And, everybody that is giving money don't like to give to everybody. All right, so we'll go. The first question is, what fundamental human rights are guaranteed under Chapter 2 of the Constitution? And please send your responses in the comment section. The first 30 people get the data. And then the second question is, what does section 6 of chapter 2 outline? So if you've been here following this, you should be able to answer those questions. So let's go. Start bringing in your responses. I will be in the comment section picking the people that bring in their questions, the first 30 people.
All right,
Okay.
let's go back to Baron. Baron, you have the mic. Thank you, Discars.
Thank you. I just wanted to address what Gwenga has said. I know that Liberty do not think it's appropriate, proper for Mr. Gwenga that answer. But Mr. Gwenga, let me just say something, because I think this has been a discussion that has gone on in the last couple of weeks about whether judges are open to criticism, or they could be attacked. So because I am a member of the I'm a barrister and solicitor of the Supreme Court of Nigeria, and I also practice in another jurisdiction, I want to change this. I think it is important for Nigeria to change this mentality of certain people are not open to criticisms. It is done anywhere in the world as a matter of core governance principle. Judges are to be criticized. Their judgments are to be critically looked at. I've been in of court where we're dining, as at that time Baroness Hale was the president of the Supreme Court, and there was a judgment that they just gave, and we brought this judgment was causing confusion. I don't want to mention, and some of us took it up with her, and she quite frankly gave us what the judges were thinking, the arguments that were advanced. And there was one thing that she considered that day, that was a negative judicial decision. And if there is an opportunity where such a question comes before the court, that the Supreme Court is bound to look at that decision in a very positive light. So in this election, people have seen, I think if you look at what had happened in Nigeria, and I think I'm addressing Gwenga so that Gwenga can take it on board. The Nigerian judiciary, in particular the Supreme Court, has opened themselves to criticism. There've been a whole lot of judgments that defy belief and logic and understanding. So it is not unheard of that judges are not to be criticized, or judges cannot be criticized. There was one that I posted recently, the two Supreme Court justices in the US is under fire. People are criticizing them. Media criticize Supreme Court justices, and justices in the UK. It's not unheard of, but it is a good time to start to look at what judgment our justices handed over to the Nigerian people, because there is this secrecy that's going on within the Nigerian judiciary that the public needs to take particular attention to. Thank you.
Thank you so much, Baron. And just to add to what Baron said, I do believe that us coming together to study the Constitution is actually a sign or an action towards criticizing the judiciary. There is no system that is above criticism. So it is a good thing what we're doing. And when you criticize somebody, you're not threatening them. What you're actually doing is you're holding them accountable. So what we're doing, when they tell you that you're threatening the judiciary, tell them that what you're doing is holding them accountable. We're just telling the judiciary to obey the law, to adhere to what our constitution has said about elections, and also about other human rights issues. So that's not threat. That's holding them accountable. All right, Liberty Champion, I think I see your hand up.
Thank you. I just wanted to, for our listeners who are listening, who are wondering what that was about. Baron, you are always a gentleman as usual. I'm not that gentle. But anyway, we know the gentleman in question. It's one thing when one is asking a very innocent and intelligent question. It's another thing when somebody just wants to lead in the narrative they want to lead. And I think the choice of word was threatened. If he had kind of phrased his question in a more diplomatic language, I think I would have been glad to give him the podium. But because it was clear that he could not hide his true leprechaun colors, so I had to call him out. But Baron, that was gracious of you to still address the main issue that he has raised. So at this point, Ugo, is it all right if the other speakers, if the scars is still mopping up the answers, if the other speakers make a contribution, maybe 2 minutes? Please, guys, summarize it 2 minutes. Don't make it too lengthy. Shall we say, Kelechi, it's over to you. You have the mic. Thank you.
Okay. I want to end with these words from Justice Nikki Toby. In 2012, he gave a judgment, and his judgment, he said these things. Now, that judgment was in the case of Nnamdi, Dr. Nnamdi Eriobuna and Ikechukwu Obiora. Now, while I read the judgment, I read part of it. He said, a judge, by the nature of his position and professional calling, is expected to be straightforward, upright, diligent, consistent, and open in whatever he does in court and in other places of human endeavor that he happens to find himself. This is because his character as a judge is public property. Mark this, his character as a judge is public property. He is the signature of the entire adjudication in the court. And like the Caesar's wife of ancient Rome, he is expected to live above board and above suspicion. If the judicial process should not experience, if the judicial process should not experience any reverse or suffer any detriment, a judge should know that by the nature of his judicial function, he is persistently and consistently on trial for any improper conduct immediately before, during, and immediately after the trial of the case. Now, to the last guy that asked the question, this is a judge of a Supreme Court of the blessed memory. He's dead, he's late now, so he's a judge of a Supreme Court. This was part of his judgment that he rendered in court. So make of it what you want to make of it. There is no law that says Nigerians cannot speak on any matter. Nigerians have every right to air their opinion. They have right of audience. They have right of expression. They have right to communicate and freely express themselves whatever how way they feel in a constructive way. So wherever Nigerians and citizens of Nigerians have by their own way championed this kind of criticism, it is allowed and it is not outlawed. So my dear brothers and sisters, as we keep faith in the country, let us always remember that the country is for us. No matter who pays you or no matter where you feed from, the country, the betterment of the country is for all of us. Thank you so much.
David, you got 2 minutes to make your submission. Thank you. David, can you hear me?
Yeah, I can hear you. Thank you. Well, Liberty, quite frankly, you shouldn't be bothered about people like Benga. We are legal practitioners here. There is no leading question that we cannot handle. As a matter of fact, I cannot speak for my colleagues, but, well, I can speak for myself. I was a prosecutor for nearly 6 years. So let him ask the question. We know how to handle him. You don't need to be bothered about that. I'm sure even my colleagues here, we know how to handle him. And my colleague there, Mr. Baron, handled him well. So don't worry about that. I raised my hand. Ugo, if you don't mind, let's connect together. Let's talk about the 1963 and 1979 Constitution. I'd like to connect with you. I will follow you. Let's talk about it. I don't like arguing on spaces like this. I don't feel that this is the place that we need to be arguing. Let's talk behind the scene. So I will follow you, my brother. Let's talk behind the scene and let's deal with it and let's come to a compromise there. Okay. I also just wanted to quickly read. Article 89. Article 89 of the ECOWAS Treaty. Speaking of international law, this is what this whole thing about Niger and all that, this is what presides here, the ECOWAS Treaty. because an ECOWAS matter. So I'll just want to quickly read Article 89. This treaty and the protocols which shall form an integral part thereof shall respectively enter into force upon ratification by at least 9 signatory states in accordance with the constitutional procedures of each signatory state. Let me read this again. This treaty and the protocols which shall form an integral part thereof shall respectively enter into force upon ratification by at least 9 signatory states in accordance with the constitutional procedures of each signatory state. I don't know what that says to my colleague, but what that says to me is that with regards to any joint mission that has now been approved by 9 members itself, each signatory member must agree to it by following the procedures of their own respective sovereign countries. That's to mean that if for instance, if Nigeria parliament says no, unfortunately, while Tinubu may just tag along, he may not be able to take any military action. That's what I see that to mean. And please, if we can just go back to that. Ugo, I want to connect with you. Let's talk about this behind the scenes. Thanks a lot. Thanks.
No problem. That's fine. Thank you.
Thank you very much, Ugo. Do you have a general comment, not in response, so you guys can take that behind the scene, but anything to round off before we give it back to the host?
Okay, thank you. Yes, I do have a short comment. I absolutely agree with my learned colleagues. I agree with Baron. I agree with all of you. What we're doing is what is expected of citizens in a democratic society. We are holding the judiciary accountable, not just the judiciary, other branches of government. I think that judges should be treated with dignity. They should be respected. They are eminent members of society. But the judicial power comes with grave responsibilities. In the discharge of their duties, they must be accountable to the Nigerian people. Any idea that says judges should be shielded from critique is a strange and anti-democratic doctrine. It should be rejected decisively. What we're doing is we are creating a culture of accountability. We're holding judges accountable in the advanced democracies that we admire. I mean, I don't necessarily want to hold up the US as a model, but if you need to hear the kinds of criticisms that US Supreme Court judges, for instance, are subjected to when they hand down decisions that are regarded as incorrect or unpalatable to the public. So we must start to scrutinize the things that happen in our courtrooms. At the moment now, we're awaiting the judgment of the Court of Appeal, sitting as the Presidential Election Tribunal. And that judgment, whatever decision those judges hand down, will have far-reaching consequences for the lives of over 200 million Nigerians. Essentially, the judgment will determine who gets to govern Nigerians. That is a grave responsibility, but in deciding such a serious issue, they must be accountable to the Nigerian people. One of the points of criticism, for instance, I have of the court is that they were completely retrogressive in rejecting the request for live broadcasts. The Nigerian people had spoken. Life, I know, for instance, you were very involved in the petition that was put out, circulated. Thousands of people signed, demanding that we see transparency in the courts. That is the basic minimum that we expected from the judiciary. That application was put before the court by many of the opposition parties. It was rejected by the court on flimsy reasons, and on that basis, many Nigerians criticized them. When we criticize judges for such decisions, we are acting within the boundaries of our constitutional rights to express ourselves, to hold views, to exchange and disseminate ideas. So I absolutely align myself with the views expressed by other lawyers here. There's no question of violence here. Nobody has threatened the judges with violence. What we've said is you have judicial independence, you have these awesome powers as judges, you have to be above board, and in whatever decision you hand down, ensure that you have your accountability to the Nigerian people at the back of your mind. And that's the thrust of all the discussions we've had here so far. Thank you.
Thank you so much. Barrister Juliet, 2 minutes, then I hand back to the host.
Okay, yes, my colleague they have actually said a lot with respect to the question of constructive criticism of the judiciary. I would like to state that the judiciary is an arm of government, and also we should actually the people should actually criticize each arm of government, criticize the government and their acts. And we've actually seen there's been a decline of judicial activism. That's from their own ends. We saw the likes of our learned colleague, our learned senior Mr. the Great Oracle, when he talked about the past we had judiciary that were always active, the likes of Oputa Pane and all that. This is just something like that. But this time around, it's not the judiciary that is actually organizing citizen and such activism. So it's necessary for us to question certain acts of them. Is best enough since they've started. We've seen a whole lot of them massaging the other two arms of government, which is not right. We've had a lot of threats, yes, to their persons, and it's a two-way thing. We're actually doing this to actually protect them, under the invasion and the infringement of their own constitutional rights by the other two arms of government. So it's even necessary for us to put them on their toes, because so they won't say they are gagged, or they won't say they are scared. They won't say that democracy has stifled their own function. So it's even necessary we continue to engage in such constructive criticism, because we, the citizens, also have a right for them to interpret our constitution the right way that we, the people of Nigeria, has sworn to actually obey. Thank you.
Thank you so much. On this note, I know some people are requesting the mic. Unfortunately, we are not accepting any more speakers. We will have another occasion. You will have another opportunity at the next space. I'm really sorry you came very late. So at this end, I'm going to hand over to the host. Host, you have the mic. Thank you.
Thank you, Liberty Champion. Thank you, everybody that showed up today. It has really been a very insightful and educative space. We actually wanted to run this for 2 hours, but we ended up going into 3 hours. I learned so much, and I want to appreciate all the guest speakers, all the co-hosts, everybody that contributed and everybody that showed up. I see Violent Space. Thank you for streaming our space on your YouTube. I see Magnificent, the Sea, Chinye, Mr. Home, Big T, and also I want to appreciate P2B Mobilization, um, Aaron, Mr. David, Barrister Juliet, Kelechi. I appreciate everybody. Don't forget to respond to the trivia questions. It's 2 questions. Go in the comment section and drop your answers. So the best 30 questions, the best 30 answers, will get data from this space. So if you join the space today and you are studying the Constitution with us on Twitter, kudos to you and keep doing that. Invite your friends, share, so we can get as many people as possible educated about their constitutional right and get more Nigerians, more young Nigerians to be active citizens. So we actually decided that instead of running this space weekly, we decided to be doing it twice every month, just to give us time to study more of the pages on Twitter, and then also not to pressurize people, because there's just so much going on in Nigeria right now. But our constitution is very essential. The more we understand it and question it, the more our leaders will engage us in a better way. Because you knowing your right as a citizen, it changes your mentality about the way you look at leaders and the way you look at leadership. So thanks everybody for joining us. We will come to the end of the space. Thanks everybody. Thank you. I appreciate everybody.
Before you close the space, host, I just want to appreciate the speakers. I want to appreciate Ugo. I simply just sent you a message and you turned up here. Thank you. I want to appreciate Baron, Barrister Juliet. Every time you and me, we are sister for life. I want to appreciate David. I want to appreciate the great Oracle, Barrister Kelechi, and thank you so much. And the other co-hosts, Wayemi Discuss, and Peter Obi, Grassroots Mobilization. Thank you so much. And everybody listening, Violence Space. I just want to crave the indulgence of our amiable guest speakers, please, we'll be having this by fortnightly, and would really appreciate if you will still honor us, because there's still so much question we want to ask. There's still so much we want to milk off you, that you know, it's just been wonderful. So I just want to get a quick yes from you guys that you'll be honoring our invitation in 2 weeks time. So put us down in your diary. Baron, yes, no? Off your mic, Baron, and commit on space.
Well, Liberty, you know, it's always very difficult to turn down certain requests, especially when it comes from Nigeria. What can I do? I will always be there. Thank you.
Thank you.
Thank you, thank you, Baron.
Thank you. And Ugo, yes, no? Put it in your diary 2 weeks from now.
Yes, I consent.
Thank you. That is the
Thank you.
Juliet. All right. And David?
Well, Liberty, I'm always here. I'm up for it, even though I'm very busy with all my work, but I will always come through. Thank you.
Barrister Kelechi?
I am at your mercy.
Thank you so much. Host is
Thank you.
over
Thanks,
to you.
guys.
Now we've secured our speakers. Host is over to you. Thank you. You can host.
Okay. All right. So the next thing I wanted to add is just let's carry everybody along. Bring your friends, tell your friends about what we're doing, and just bring in more people to be more aware of our constitution. Thank you. And then I will yield at this point. Thanks everybody for coming out.
Bye everyone. Thank you. Bye-bye.